Welcome to Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney.
Hey everyone, welcome back to an all-new episode of Courtroom Quarterback, the experiences and thoughts of a court-martial defense attorney with attorney Joseph L. Jordan, the founder of the Jordan UCMJ Law Group. I am your host, Mike Leon. You know, Joseph here is a former Army JAG and worldwide court-martial defense attorney, and he's tried more than 240 court-martials to verdict and handled more than 350 military cases all across, not only here in the U.S., but Europe, in the Pacific, and in the Middle East. And in today's episode, we're going to be stepping into what Joseph considers probably the most important part of a defense lawyer's craft, and that's the cross-examination part of this, right? So, Joseph, you're going to explain all this in just a second, why it's so crucial. But this is part one of a two-part series that we're going to do. We're going to focus on the purpose, the discipline, and judgment before even a single question is even asked. Joseph, it's good to see you as always. So I just mentioned that you think cross-examination is the most important thing that a defense counsel does. Why is that? Why does it sit at the center of your practice?
Well, first of all, good afternoon. When I think about cross-examination, I think of it as the tip of the spear. It is the arrowhead. It is what you use to pop the balloon of the government's case. You are at the tip of the spear when you are cross-examining witnesses, particularly accusers. And in my business, I would say almost 90% of the time, I'm cross-examining an accuser, an alleged victim, someone that has a grievance where they say they've been harmed in some way, shape, or fashion, whether it's sexual assault, domestic violence, larceny, theft, burglary, those sorts of things. So being able to take apart the witness and their story is where you win cases as defense counsel. It is the most important job of a defense counsel, is to have effective cross-examination of each and every witness that the government counsel, the prosecution, puts forward.
Joseph, you know, if you think of the law shows, right, you think about cross-examination, and two things happen, right? You're either trying to credit a witness or discredit them, right, with respect to direct and cross-examination. How do you kind of determine which of those serves the case that you're working on?
Sure. So your overall strategy is what dictates that, right? So there may be circumstances where you've done your homework, you've interviewed the witnesses, you have a good idea what the expert may say, or the witness may say, and you want to use that information to help your case move forward. So maybe you do credit them. With experts especially, that's one thing that you want to do, and show the nuances and differences of your case vice what they're presenting. Most of the time, though, you are discrediting a witness in some way, shape, or form, especially if it's an accuser. And the way you do that depends on the individual, their experience in life, the nature of the circumstances of the case, those sorts of things. So it just depends on the strategy of the overall case and what you want to accomplish with each particular witness that you're cross-examining.
Well, let me piggyback on that. So what in your mind, for the people that are listening, watching to this, what's the ultimate goal of cross-examination in your mind? What should it accomplish? If you do your job really well on cross-exam, what does it accomplish?
Teach the jury what you want them to know. Oftentimes, people think it's the answer that matters when you're questioning a witness. On direct examination, that's true. But on cross-examination, the question is what matters, not necessarily the answer. You want the jury focused on your questions, okay? You want the military panel focused on the defense counsel's questions and what they're asking, because that triggers in their mind critical analysis of the problem, right? So you want them walking the path that you're walking. You want to bring them on the trail with you as you question the witness. And many times, you're in the military especially, you're dealing with very intelligent people that are a lot more experienced in life. In many cases, they have a degree. Even your enlisted members, if they're a non-commissioned officer, they'll have a degree. They'll have a bachelor's degree. They'll have an associate's degree. So they know what it means to critically analyze problems, and they lived life. So you want to bring them along on the trail and highlight things that they may take for granted and think about daily, but you sit there and you highlight certain things, and you bring the visceral reality of the situation. When I cross-examine witnesses in domestic violence cases, in assault cases, in sexual assault cases, my style is to bring the visceral reality of the situation to the table, okay? So that means we get right down into the nitty-gritty of what happened in the bedroom and whether or not there was penis to vagina penetration and how did that work, right? The dynamics of putting on a condom before you actually enter into the act of sex. That's how visceral and how you have to get. And that educates the panel. It makes them think about these things, not on a cloud level or an abstract level, but on a very real level. And that's where I find that we're able to connect with juries and win cases, especially in close calls.
Joseph, what about the times that maybe it didn't get up? No questions, Your Honor. You don't cross-examine at all. Well, can you take us through the times that you've done that? And has it been smarter to sit down instead of standing up?
If there's nothing to accomplish with a witness, why question? It sends a signal to the jury, too. Oh, that witness isn't that important. Well, they didn't even think to question them. Why? What was the point? Right? So the jury will dismiss them oftentimes when you do that. But it is a careful analysis. You don't do that with every witness, obviously. But if there's nothing that you can accomplish with them, they're the immovable object, then there's no point in questioning them whatsoever.
Yeah. Let's talk a little bit about your preparation that you've talked about in previous episodes for this stuff. What is the real preparation? Get in the weeds for us. What does it look like for you before you even step foot into that courtroom as you're preparing to potentially cross-examine all these witnesses?
This is one of my favorite parts of the case, is the preparation for cross-examination. And first of all, the first thing that I do is I read the whole case file. I get a very big picture, 30,000-foot view of the case file. What does this thing look like? Big picture. Then I start to develop my strategy, and then I start to funnel down on the key witnesses that are going to turn the tables on this case. Where's the case going to turn, right? And eventually you drill down to the alleged victim. And you look at all of her statements. And usually with a military case file, you're going to get a summary of statements initially. And then as the discovery process develops, you will eventually get their actual statements. In most cases, it's an audio-visual statement, so a recorded statement of the interview that the investigators have with the alleged victim and other witnesses. And so I make a judgment call on, do I want to transcribe that or not, right? So depending on the importance of the witness, what critical analysis, or the critical analysis that we do, and how critical they are to the case determines if I want to transcribe it. We transcribe it, and we break it down, and continue to break it down. Then I will start to look at other things. I will look at the behavior of the witness, and that's based off of observations of other witnesses that may be friends or peers or acquaintances of the alleged victim, right? Or of our client as well, depending on behaviors and those sorts of things. So as I've probably stated before, when I look at sexual assault, I look at it as a wagon wheel, and the accuser is the hub of the wheel. All the stories that she tells are the spokes of the wheel. So every person that she's talked to about the case, which people commonly call as outcry witnesses, those are spokes of the wheel. And so I look at those spokes and determine what's consistent and what isn't. And you can start to develop a cross-examination strategy based off the various stories she tells. But then you also look at the actual statement that the individual has made, right? So what has the accuser said? And is there any inconsistencies within what they have said? What were they led to have said based off the interrogation or the interview, rather? So during the interview, you're looking at, did the agent lead them one direction or another, right? So, and each witness that you prepare for is different. You prepare for an expert differently than you prepare for an accuser. You prepare for a child victim. You prepare for a peripheral witness that has something to add to the table. So everybody's a little different. And what you're looking to do is to build, you're building a project. You're building a puzzle, as it were. Legos is one of my hobbies. So you're putting together the Lego project to present to the panel. And so you have to sit there and manage and strategize and then figure out what tactics you're going to use to get there, depending on what witnesses you are examining.
Big Lego guy myself, so I get the references when my daughters hand it to me and I have to put it together. So, but speaking of stories, because you mentioned the word stories, I'm sure you have some stories from cross-examination, especially where this preparation that you've done so extensively paid off. Can you share a case where being fully prepared for that case kind of created a decisive shift once you started questioning?
Sure. I've got multiple stories for this particular case that I have in mind, and it's a case that I did years ago in Italy. I remember it vividly because of kind of the entertainment value that this thing brings. So the situation is this: my client was really, really drunk. His buddy was about 6'5", 240 pounds. He could have been a tight end for an NFL team. They're drunk off their rears, right? So for some reason they got a hold of a shopping cart, and my buddy gets dumped into the shopping cart, and they wheel it into the lobby of the barracks on Del Den, which is this really lovely facility in Italy. And the facility and the way it's set up matters as it relates to this story. So and there's a lot of things to pull into this. So one, value of going and walking the scene and seeing how everything is, right? So you go to Del Den Barracks and you see that you've got these 20-foot glass windows. And at night, so I went during the day and then I went again at night, it lights up the whole foyer area. And it's a nice big foyer area. There's a seating area with a TV. There's another, on the other side, there's a pool table, which becomes important to this story. So my guy gets wheeled into the foyer. And he gets up out of the shopping basket and he walks up to the NCO, the non-commissioned officer, who's a female, who's in charge of watching the barracks that night. They call it, CQ, charge of quarters, or fire watch, whatever you want to call it, right? But she's in charge, making sure everything's safe that night. Well, my guy's drunk, and unfortunately for this particular individual, she was known to have a certain type of reputation, and my client was a young PFC. He walks up to her and he's like, well, when am I going to get my turn? And he starts flirting with her. And his buddy sees what's happening and he says, look, let's just get you to your barracks room. So he gets my client to the barracks room. Client comes back down sometime later and continues to flirt with the NCO. And from this flirtation comes allegations of attempted sexual assault. And what she describes is very interesting. And I was able to prepare one of the more entertaining parts of this cross-examination based off of her interview that she gave to CID, Army Criminal Investigative Division. And first of all, I looked at the fact that she's an NCO and I questioned, like, hey, you're a non-commissioned officer. You have command authority and you should use it. And you didn't in this case, right? That's kind of how I started the cross-examination. So knowledge of the Army culture, knowledge of the individual and their capabilities and what they didn't do, right? Next, there's a lot of things to work with in this case. So she had several motives. She didn't want to be she didn't want to be in Italy. She wanted to be back in the States. We were able to suss that out by interviews of peer NCOs, supervisory NCOs, those things of that nature. But she said something that was very, very curious to me. She described the situation where my client was allegedly coming after her, and she decided that she didn't have anywhere to go. So she went and she sat on the pool table. Now, here's an interesting thing. Everybody knows what a pool table looks like. You know how high they sit off the floor. She was about 5'1". So if she's sitting on the pool table, she's not in a position of power or a place to protect herself. What do we know that's on pool tables? Pool sticks and pool balls. And she described picking up the balls and playing with them while she's trying to figure out what she is going to do next. Picking up the pool stick as she's thinking through her next steps. And she literally said, not only in the interview, but on the stand, that as she's sitting on the pool table trying to get away from my client, that she didn't have any tools in her toolkit left. She didn't know what to do. So in my cross-examination of her, I had prepared this and practiced it. And I walked the dog on this. So you sat on the pool table, not a position of power, is it? No. You said that you picked up the pool balls and played with those, right? Yes. You had the pool stick in your hand at one point. Is that true? Yes. So as you're playing with the balls and playing with the pool stick, you didn't have any tools in your toolkit at all? It's one of the only times in my whole trial experience that I got the judge to laugh, multiple members in the panel to laugh, and the gallery was, they were quite entertained. Needless to say, that was a very short deliberation in that case. But it's just, I had the interview to work with, and I was able to practice, and just, that's what I mean by taking the visceral nature of a case in a situation and bringing it to the jury and saying, look at how stupid this is. Look at the ridiculous natures of this situation.
Yeah. A lot of phallic symbols in there. I would have gotten it as I was on that jury. Joseph, we leave it there for part one. Thanks as always, my friend. Continue success.
Yep.
And thank you to everyone out there for listening to this installment of Courtroom Quarterback with attorney Joseph Jordan. If you want to learn more about Joseph's worldwide court-martial defense practice, like that story you just heard, visit jordanucmjlaw.com right now. And do me one more favor before you go. Hit like, hit subscribe, leave a review, comment. Share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.